identifying the constitutional recognition and privileges of the transgender community, has been thoroughly considered in the NALSA judgment, and no further reliefs can be conceded to them. 5. Sec. 377 has been consolidated after observing the legal system and standards which prevailed in ancient India, and the said section in the current scenario is relevant lawfully, medicinally, ethically, and constitutionally. 6. People indulging in unnatural sexual acts made culpable under Section 377 are more receptive and are at higher risk against HIV, AIDS, and right to privacy can't be expanded out to empower individuals to indulge in unnatural offenses, and in this manner contracting HIV, AIDS. 7. Fundamental rights are not absolute, and there is no unreasonableness in Sec. 377. Furthermore, decriminalizing the section would run foul to all religions practiced in the nation. And while choosing the ambit and extent of constitutional morality, Article 25 additionally has the right to be given due thought. 8. In the event that Section 377 IPC is struck down, it would render the complaints related to forced acts secured under the current Section 377 IPC remedialess, as the said section not just encroaches on carnal intercourse against the order of the nature between two consenting adults, but in addition, applies to forced penile non-vaginal sex between adults. It would likewise render a married woman remedialess under the IPC against her bisexual spouse and his consenting male partner. 9. The offense under Sec. 377 suggests sexual perversity, Faisal Rab Chaudhary Veer, territory of Bihar, and includes carnal intercourse between two people, which is offensive, harmful, and against the order of nature. It is well inside the purview of the state to put reasonable limitations on it. 10. The doctrine of manifest arbitrariness is of no application to the current case, as the law isn't plainly or in any way arbitrary, for Section 377 IPC is a punishable act, which is independent of sex or sexual orientation of the people. It doesn't comprise discrimination, as laws dependent on biological reality can never be unconstitutional. The interest of a citizen or of the general public, however significant, is secondary to the interest of the nation or society as a collective. State of Gujarat Var. Mirzapur Moti Qureshi Kasab Jamaat and others. 11. Decriminalization of Section 377 IPC will ruin the family framework and negatively influence the organization of marriage, open a conduit of social issues in which the legislative domain isn't capable enough for accommodating, and would likewise have a falling impact on existing laws. 12. Consent could also be obtained by misconception, unsoundness of mind, intoxication, or coercion. 13. If the court allows prayers of the petitioners, then that would lead to judicial legislation, as the courts have no power to add or delete words into a statute. It is stated that the words consent and or without consent is not mentioned in Section 377 IPC, and therefore, such artificial distinctions cannot be made by the courts. Sakshi v. Union of India and others. Analysis and summary of judgment. Navtej Singh Johar Ors, Union of India. The judgment for the present case was pronounced on the 6th of September 2008, where a 5-judge bench unanimously struck down Section 377 of the Indian Penal Code as unconstitutional to the extent it criminalized consensual sexual intercourse between two qualified adults of same sex. The writ petition was presented by the petitioner Navtej Singh Johar before a 3-judge bench, which felt that it was deemed fit to be considered by a larger bench. The apex court referred to the Suresh Kumar Kushal versus Naz Foundation case, where the court declared the provision to be intra vires and overturned the decision by division bench in Naz Foundation versus Government NCT of Delhi. The court broached upon disparate arguments such as social morality, determination of order of nature, fundamental rights, foundations of our Constitution, statistically minor community, etc., thus giving a landmark judgment. The case took into consideration profound questions of law and morality, which had significant implications and consequences on our society. Section 377 IPC states that whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years, and shall be liable to fine. The debated language of the provision carnal intercourse against the order of nature remains to be ambiguous and vague to the extent that no defined meaning was attributed to it. Sexual intercourse between two people of same sex was considered to be an unnatural offense, which was against the order of nature. This provision stems from the Victorian-era law, which is long gone, and there is no need for the continuance of the same, as they are violative of Articles 14, 15, 19, and 21.